And those events and all those experiences, parent dying or an estrangement, should prompt people to say, how does this impact my estate planning?
Welcome to another edition of Perspectives. My name is Rob Pizzichetta, founder of Mont Wealth, and today I have Elizabeth Cummings, principal from Conlon Cummings Lawyers. Welcome, Liz.
G'day, Rob. How you going? Are you
Fun.
going to tell everyone how long we've known each other?
Yeah, Liz and I went to primary school together. So people know how old I am, so you're the younger than me.
Yeah, I think we might have been in prep together.
Yeah, it's a bit, and then I was held back thereafter.
Yeah,
It's good fun.
so thanks for having me, Rob.
No, pleasure. So tell us a little bit about your business and how you got into it.
The law is a family game, and my father started practicing in Essendon, Go Bombers, in the 1970s. And yeah, he practiced there. His brother's a lawyer too. He was practicing in the same industry. And then I studied law eventually. But I started working with Dad. So that's 25 years ago, something like that. Dad's been practicing for 55 years this year, which is pretty incredible.
Amazing.
And he's still working. He works 3 days a week and he's going to be 80 in January. He does his Sudokus every day to keep himself on track. And yeah.
I'm a bit like that. I can't see myself retiring. I think you're a long time retired, so you might as well stay active mentally and physically. So good on him.
Yeah, he doesn't play golf, not too fit for that. And there's only so many lunches you can have in a week. So you might as well work a few other days. But I started out back in the day when I was a uni student doing the conveyancing settlements up and down Burke Street and Collins Street. I knew where all the banks were, and that's when you had to go in physically, and if the checks weren't right, you got sent away to come back again. So yeah, that's what I first started doing, and then did my articles, and here I am doing mostly family law and estate planning and probate work. But my background is in commercial law because my father's a business law specialist and has been for a long time. But there's 7 lawyers at our firm and we're in Ascot Vale.
You're great. That's a good little business.
Yeah.
So congratulations to you and your dad for what you've created there. Now, we were meant to talk way back when, and then suddenly there were some changes in tax policy, and Dr. Chalmers and Alvo came in and made some changes. What's changed, or what hasn't changed?
We were all scrambling because they said that testamentary trusts or trust rules generally or taxation on trusts was going to change, discretionary trusts. And there was lots of CPD sessions being booked in to work out what it all meant or would mean once there was legislation. And then they announced that they were backtracking, specifically in relation to testamentary trust. Well, we were contemplating whether clients would have to all come in and re-sign wills, which would have been good for business, but not ideal. But now it's as you were type scenario because they've done a backflip on the testamentary trust aspect.
That's good. So is there any scuttlebutt around of any other potential changes in the future, or?
One presumes that it wasn't taken well. There's this big thing in Australia. I think everyone, and the Herald Sun loves to worry about death taxes because we don't have death taxes, but they're always worrying about death taxes by stealth, something that they don't call death tax, but ultimately is. So the proposed changes were that the trust itself was going to be taxed rather than just the recipient, beneficiary. So that was going to be a significant change, and we were going to have to advise people that had testamentary trusts in place about the significance of it, because some people signed testamentary trusts because we recommended them because of the tax benefit. And if that was going to wholesale change, that was a problem for us on an advice point of view. But I think it was 6 weeks later, they changed it just after my firm had finished drafting communication with the client about what we thought it was going to mean. Because, of course, we didn't have legislation either, which is the other complication. Yeah. The finer details aren't there. And we start getting emails and all sorts of things from worried people.
Yeah, we had similar instance in superannuation where proposed changes that weren't yet legislated, and then there was no point doing anything until they were legislated because otherwise you could have been moving without and need to.
Yeah.
So
Yep.
yeah, there's no point moving ahead of that.
No.
Okay.
No. Yep.
All right.
No. As you were.
As you were, which is good to hear. Now,
Yeah.
obviously, I want the listeners to better understand how estate planning works. Now, can you give us a bit of an understanding of what a testamentary trust actually is and some of these discretionary family trusts, how they work and who they benefit?
The idea of a testamentary trust in a standard family scenario is that you are looking to gift your children their share of your estate into something that's akin to what we understand to be a discretionary trust that people use in their lifetime as investment vehicles. But testamentary trusts have some additional benefits. For example, unlike non-testamentary discretionary trusts, where distributions to children don't have the same tax-free benefits. If I were to receive in a non-testamentary trust scenario from my parents' real estate, and being a lawyer, I don't own many assets in my name. So in a testamentary trust, if, for example, my parents were to die and I was holding my share of their estate in a testamentary trust and I was investing with you, what was part of my testamentary trust inheritance, and I needed to share the income that I'd derived, I could share that with my children as minors as though they're adults. So that's a really key benefit, and my children's children if I continued it on. So you have a lot of tax benefits, but there's also a state tax benefit that I use as an example. So if I were to receive real estate via a standard will, in order for me to get that real estate out of my name, if I wanted to do that, carry on the asset protection scenario, I'd have to pay stamp duty to get it out of my name.
Yeah.
Whereas if I receive it into a testamentary trust, I can transfer it within the trust or out of the trust to my husband because he's within the beneficiaries of a testamentary trust. Although I'm controlling it, I can transfer it to him transfer it to him out of the trust without paying any stamp duty. So there's all sorts of examples. If I were bankrupt when my parents died, it would be protected,
Yeah.
even though because it's coming into a testamentary trust. So it's not actually my asset, although I'm controlling it until it referred out of the trust to me or any other potential beneficiary. So there's all sorts of benefits to a testamentary trust. I think at one CPD seminar I attended, someone was talking about a rule of thumb should be that if a beneficiary is going to be receiving $500,000, they should be receiving into a testamentary trust. But the other thing is, you're not forced to have this investment vehicle that you carry on for years and years. You can also say, you know what, thanks Mum and Dad for giving me the options. I've got it in the testamentary trust, but I really just want to pay off my mortgage. I'm going to do that. So there's no enforced carry it on for generations, but there's the option. Whereas if you receive assets via a standard will, it comes into your name and you've got limited options from a tax and asset protection basis.
Got it.
Yeah.
A choose your own adventure book that we would have
Yeah.
taught in primary school.
Yes.
And it's a bit like what we try and do, where we ask the client, all right, what are you actually trying to achieve here? What
Yes.
do you actually need? So
Yeah.
as part of this, do you sit down with parents, kids, adult kids, and go through that process, or is that a private conversation?
It's usually private. Sometimes adult children are present for some reason, but I'm wary of those situations
Yeah.
because lawyers have got to be careful about ensuring that people aren't under any undue influence when making their will. So I'm cautious about that. But sometimes adult children are involved because the person doesn't drive. It doesn't have to be a nefarious scenario. And sometimes it's family dynamics. They rely emotionally on this child of theirs and they want to chat it through in front of you with their child there or children. So, yeah, but it's usually just one person. And we've got to be cautious about people having capacity to make will because everyone's living too long these days. And capacity is becoming a growing issue, and certainly dealing with the probate office when they're looking at wills at the other end. They're hot to trot on causes of death and anything that can involve an impact on capacity. They want to know when the capacity was last assessed and all sorts of things. So it's something that's more and more. Yeah.
That's good. All right. We're going
Yeah.
to build now on the timelines of probably age brackets. Now, what's important for a 30-year-old single or couple with kids? What's most important for them? Because I'm trying to get the listeners to understand how to protect themselves at the moment.
So 30-year-olds with kids, one of the key things that they've got to think about is guardianship for the children if both the parents die before the kids reach adulthood. And it's not a mandatory nomination, but I think people tend to consider it and discuss it with family members. And certainly if there's argy-bargy within the family, they want to make sure it's not such and such. But that's also not a binding situation. So if you nominate your brother Tommy to be your kid's guardian, and if the situation arises and Tommy's got 6 of his own kids and really can't handle 2 more or whatever, then he's not forced to carry out the role. Yeah. So I think it's just an expression of a wish. But I think in the same vein, it's also, you've got to think about who would be guardian, but also who would be trustee for the kids' inheritance or trustees for the kids' inheritance until they reach adulthood. We recommend that it's someone that's different from the guardian. So there's an arm's length situation. If the guardian wants to take them to Disneyland for the 5th time in 3 years, then the trustee might say, I don't think that's appropriate. So I think there's those things to think about, and whether you have one person from each side of the family and all those sorts of things, and whether the trustees are the alternative executors, because most people, the first level is I appoint my spouse as executor and I give them everything. If my spouse hasn't survived me, then what happens then? So it's alternative executors, trustees and guardians. Yeah. So they're the things that people with kids have to be thinking about. People in their 30s that don't have kids, they're another interesting one, because I think they tend to think that they don't need a will. And they do, because they don't have a will. Intestacy law says that it goes where the law says, and that's it. So I think if people are informed about intestacy and say, oh, you know what, that's okay with me if that's the way the cookie crumbles. But mostly people want to choose where their assets go rather than have a legislator decide on a black and white scenario that it goes to my mum and dad or my sibling or whatever.
Yeah.
Yeah, that's people in their 30s. And I also encourage people in their 30s to sign enduring powers of attorney and appointment of medical treatment decision maker, because that, although that's not a death scenario, that's a scenario where you have lost capacity and you can't look after your own affairs. And that can be short term, it can be long term, it can be permanent, but that happens usually suddenly and unexpectedly.
Yeah.
And if it does happen, you can no longer make that decision yourself. And you can't nominate someone. Once you lose capacity, you really have lost autonomy. So the idea is to ensure that the people you want to help you in that scenario are armed and ready to assist as soon as an issue arises. Yeah.
I understand. The other advice I'd give to 30-year-olds would be check your superannuation statements, make sure that you've got the right person as your binding nominee.
Yeah.
And the other thing of note too is you've probably just gone out and bought yourself a home, you've got a bigger mortgage, make sure your life insurances are all sorted and you've got a large enough sum to cover that. So on the legal side, but also on the financial side, it's important to be on top of all those things.
And also binding death nominations, sometimes they expire after 3 years. So give yourself a reminder if that's the sort of fund you're in, to make sure that it's,
Binding. So we move on to our 40s. We're probably starting to get teenage children now. Our mortgages are a bit bigger. Maybe our asset base is a bit bigger. What's important for a 40-year-old or 40-year-old couple, single, however we want to look at it?
If they're 40-year-olds that did their wills in their 30s, they should be thinking about whether there's been any life changes, should prompt them to reconsider their wills or enduring powers of attorney or whatever. So that can include the death of your own parent or divorce. All sorts of life events can impact your estate plan. But if they haven't had a will, then it's their first will. I think if the kids are only teenagers, it's probably too soon to make too many changes that you might have made in your 30s, but it's a question of whether you're still happy that such and such would be alternative executor and who should look after the money. And also the other thing to consider is, do I have a standard will? Do I have a testamentary trust will? I think that's the sort of age group where you're starting to shift into better wealth, probably, hopefully, and these more detailed, I think, estate plans start to come into force a bit. I also talk to these people that have got kids that are not yet adults, both in their 30s and 40s, about what age should these children receive their inheritance if, in the unlikely event, both parents die before they're adults. What age do we choose? And we recommend 25. I tend to think clients, it depends if they've got all boys or all girls. All girls means they're happy for younger. And all boys, they say, 30. Yeah, it can vary, but Dad had an experience years ago, and I was working with him at the time as a secretary. I remember a couple of kids, they were adults, but only just adults, and their parents unexpectedly died within a couple of months of each other, and they were too immature to have, and it wouldn't have been a significant estate, but it was plenty of money, more money than they'd ever known. And by the time they were in their early 20s, they'd blown it all, taken a few mates to Thailand and everything. So because of that experience, we've always said, if they're receiving it when they're 25, it's not as though the money's locked away until they're 25 and they can't access it. And if there's a trustee that's an aunt or an uncle or a friend or whatever, they're able to go to that trustee and say, look, I'd like to buy a car when they're 20. And the will provides for that sort of spending. It's just about accessing the main part that I think needs a level of maturity.
Yeah, understand.
A good level of maturity.
Yeah, that's fair. And so we're moving to our 50s and 60s now, Liz. We're getting a bit older as individuals, adult children, may have some grandchildren. We probably might even start receiving some inheritance because our parents. So how do we structure that age group, and how can you help people that are potentially going through a probate period or experience?
Oh, I think more in the 50s, just going back before probate, I think in 50s and maybe in the 40s, people are sometimes or more likely to be owning assets in trusts. And people don't realise often, I find, that your will's about your personal assets. So people like the orphan, again, Harold's son, they sometimes, and the age too, they sometimes snoop around the probate records and they tell you what such and such owned when they died. That's because that's a public record, the probate office, and you're able to get access to those sorts of details after a time. And it fails that in reporting like that, it fails to understand that they're just the assets in Joe Blow's name, right? He may have had 50 million in trust assets sitting over here, but of course that's not in his personal estate. That doesn't form part of his personal assets. So when people have assets in trusts, we also need to think about, what does the trust deed say, because it's the document that's relevant, and does it line up with your estate plan? Does it have the right beneficiaries in? Because sometimes these trust deeds have been sitting gathering dust, or well, probably not dust these days, they're online, but sitting not looked at, and you need to look at them to make sure that who's going to take control when Joe kicks the bucket, and is that the right person, and so on and so forth. So that's something definitely people need to consider. And they also need to consider, if they're in a business arrangement, what happens if Joe's business partner dies? What's going to happen there? Is there a buy-sell agreement? All those sorts of things. So there can be lots of complications, but probate's something that I enjoy. But I really like helping people at that time where someone's died. I suppose it's also why I enjoy family law. A relationship's died. But I think I like dealing with people and feeling that I really helped them. And I think probate's a moment where you can make it easy for people, but it's a bit of an oldie worldy sort of process in some respects.
Good, Liz. Can you give us some examples of your experience with probate and some of those
Oh,
relationships?
mm. So you're nominated in a will, Rob, as executor, but banks, financial institutions, all the rest don't recognise you as the executor with a capital E maybe until probate is granted. And that's because there might be a later will that you don't know about. So the whole process is you have to advertise your intention on the Supreme Court website. It used to be that you had to advertise in the papers, but they've done away with that. So it's on the Supreme Court website that you intend in 14 days to apply in relation to. And yeah, it's once that happens, we have to what's in this estate and we have to do an inventory of the estate. And they're standard forms, but they need to be very precise. The probate office is notorious for I think someone used to get a red pen out. They probably don't anymore. But yeah, and when it's dealing with people, I've got a file at the moment where they're siblings that were executors regrettably, and they can't speak to each other. We're dealing with that. And often the executor doesn't speak to the beneficiaries. Families can be complex, as we all know.
Yep.
And it's about being gentle in that scenario. And also you deal with a parent leaves their children their assets in equal shares, but there's a holiday house and one of the kids wants a holiday house, and you work through that. So, there's all sorts of stories that have, if I could dredge them all up, but it's a process that takes time and is very formal, but doesn't need to feel that way, I think. Yeah.
From that experience, sounds like even when we're in our 50s, 60s, and 70s, we should always be reviewing our estate.
Oh, yeah.
Yeah.
Yeah. So when we send the copies of the wills and enduring powers of attorney, we list in the covering letter the sorts of life events, I've touched on it before, that really we say, rule of thumb, think about it every 5 years about what's happened and how does that change my estate plan. It could be one of your adult children separated, and there are processes that we can adopt in that scenario to avoid against a family law claim on an estate. I had someone come in yesterday who needed to change her attorney because she's been diagnosed with MS. There's all sorts of scenarios, but certainly marriage invalidates your will, divorce. There's key events, but obvious events. But I think that's the beauty, isn't it? That life's forever changing, never boring, hopefully. And those events and all those experiences, parent dying or an estrangement, should prompt people to say, how does this impact my estate planning? Because they are your assets and it's your well-being in relation to enduring powers of attorney and appointing a medical treatment decision maker. It's important to take the opportunity to be in control of that, even after death and even after loss of capacity.
You understand. So this has been a very insightful conversation. So thank you for your time.
So,
For anyone that's in their 30s or 40s that needs to establish the will, or later on who needs to review it, how do they get in contact with you?
on the website, if you like, conloncummings.com.au, or phone. I like phone calls too.
Right.
Anyway they like to.
Oh, fantastic. I'll put your details on the show notes as well and your email address so that way people can make contact with you. Liz, you're a legend. Thanks so much for your
Thanks,
time.
Rob.
And chat soon, no doubt.
All right, good on you. Thanks, mate.